officers with a contextualized understanding on principles of regulations, ethics, and integrity. Connected to the establishment and administration of regulation, another objective of the training program is to equip public service officers with the understanding and tools to manage conflicts of interest and strengthen good values, ethics, and integrity towards avoiding and eradicating corruption. In-house course on torts law for legal managers. This course emphasizes the key concepts and legal rules under the law of torts in Malaysia, especially relating to negligence, occupier's liability, nuisance, trespass, and protection of reputation. It focuses on applicability of those rules in the context of business processes so that employee can learn the best practices and guiding principles learned from relevant court cases and statutes for the purpose of their work environment. Workshop on mediation arbitration. MedArb as one of ADR mechanisms is becoming an increasingly popular way to resolve disputes. It can be used in family disputes, commercial disputes, partnership disputes, landlord and tenant disputes, condominium disputes, and many others. This training aims to equip the officers with MedArb skills for their career. Diploma in Law and Correctional Sciences. Students are exposed to various fields of study, namely law, management, criminal justice, psychology, and English courses. After completing this program, students are expected to display ethical behavior and show a high sense of humanity in providing services in their work environment. This is a collaborated academic program with Malaysia Prison Department. Climate Change Policy and Law Center, CCPL Center. In 2021, ICOL researchers were awarded Erasmus Grant. The CCPL Center was established in December 2021 and is co-sharing facilities and resources with an existing center, Harun M. Hashim Law Center, IIUM. Special features of CCPL Center are multidisciplinary educational program, to address the need of a new generation of postgraduates in an LLM with specialization on environmental policies and CC law, to support the modernization, accessibility, and internationalization of higher education in Malaysia, to improve its relevance for the labor market, to attract students and stakeholders from various backgrounds, to become the heart of policymaking and formulation of legislation. The LLM Climate Change Policy and Law to be introduced by the CCPL Center will be part of the existing Harun M. Hashim Law Center's LLM International Law Program. This program is to be offered to academic staff and researchers, legal practitioners, policymakers, project managers, auditors, and government officials, graduates from environmental sciences, social scientific environmental studies, natural sciences, or environmental engineering, or an appropriate field in social science or law, national and local leaderships, think tank, private sector, and civil society. CCPL Center, with support from the Harun M. Hashim Law Center, is also tasked to organize conferences and networking, conduct meetings with partners and stakeholders, support research and publication, undertake dissemination, exploitation, and networking activities. Contact us or visit our website for more info.
May we have your attention, please? This is a public safety announcement. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to International Islamic University, Malaysia.
You are now in the Senate Hall.
Upon the sound of a fire alarm or when evacuation order has been issued, please evacuate the building immediately. Emergency situations can be triggered by the presence of potential hazards such as fire and natural disaster.
This hall has 6 main emergency exits.
Please take notes on emergency evacuation routes, locations of exit doors and staircases. During evacuation process, please remain calm and walk to the nearest exit according to predetermined evacuation routes. For faster and safer evacuation process, please refrain from talking and running. Once you are outside the building, please proceed to the nearest assembly point and wait for further instruction. Thank you for your attention. This
Kalau ada presenter nak pakai step dah ni. Oh, kita bagi dekat ni. Cuba kita bagi dekat Aisyah terus. Announcing the arrival of Professor Dr. Akmal Khuzairi Abdul Rahman, Mr. Timo Guzman, Mr. Ahmad Farid Muhammad, Assistant Professor Dr. Wan Muhammad Zulhafiz Wan Zahari, Yang Arif Datuk Lim Chong Fong, Miss Pam Adams, Miss Kwong Chiu Yi, Mr. Q Jayao, and Associate Professor Dr. Mazatul Mustafa. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh and a very good morning. Honorable guests, ladies and gentlemen, kindly put your handphone on silent mode. Alhamdulillahi Rabbil Alamin, wassalatu wassalamu ala ashrafil anbiya'i wal mursalin wa ala alihi wa sahbihi ajma'in. Rabbi fil lana wa liwalidayna warahmuma kama rabbayana saghira. Let us all begin our symposium today with a recitation of Al-Fatiha. A warm greeting to the Honorable Professor Dr. Akmal Khuzairi Abdul Rahman, the Deputy Rector, Student Development and Community Engagement of International Islamic University Malaysia, IIUM, Mr. Timo Guzman, the Deputy Head of European Union Delegation to Malaysia, Mr. Ahmad Farid Muhammad, the Deputy Secretary for Climate Change Division from Ministry of Natural Resources, Environment and Climate Change, Malaysia, Assistant Professor Dr. Wan Muhammad Zulhafiz Wan Zahari, the Deputy Dean for Academic and Internationalization of Ahmad Ibrahim Kuliah of Laws, ICOL, representing the Dean of ICOL, Yang Arif Datuk Lim Chong Fong, the Judge of the Court of Appeal, Malaysia, Ms. Pam Adams, the Sustainability planner at the Central Region Council of Government of Pennsylvania, Ms. Kwong Chiu Yi, the partner at Rahmat Lim and Partners, NYC Professional Fellow, Mr. Q Jayao, the Deputy Co-Chair for Environment and Climate Change Committee of the Malaysian Bar Council, Associate Professor Dr. Maizatul Mustafa, the Director of this International Symposium, and the Coordinator for Climate Change Policy and Law Center, CCPL IIUM. Honorable guests, ladies and gentlemen, welcome to the International Symposium on Environmental and Climate Change Mediation, organized by Ahmad Ibrahim Kuliah of Laws, Climate Change Policy and Law Center, and Harun M. Hashim Law Center, in collaboration with the Young Southeast Asian Leadership Initiative, YCLE Professional Fellows Program. My name is Ahmad Muslim Rozlan. I am the Master of Ceremony for today's symposium. Honorable guests, ladies and gentlemen, the symposium is a platform meant to provide a high-level dialogue, mutual learning, and mediation training in order to enhance the understanding of environmental law and climate change as an important aspect of policy decision and governance. To discuss solutions on climate change policy actions at the national and international levels, to enhance capacity and participation in climate change action, as well as to support academic interactions and networking with various sectors. Before we proceed with the main agenda of this symposium, kindly watch the video presentations prepared by CCPL Center and IIUM. Please enjoy. Without further ado, I would like to invite Assistant Professor Dr. Wan Muhammad Zul Hafiz to give his welcoming remarks. Please welcome, Doctor.
Thank you, Mr. Chairperson. Bismillahirrahmanirrahim. Alhamdulillahirrahmanirrahim. Wassalatu wassalamu ala ashrafil anbiya wal mursalin wa ala alihi wa sahbihi ajma'in. Professor Dr. Akmal Khuzairi Abdul Rahman, Deputy Director, Student Development and Community Engagement, International Islamic University Malaysia. Mr. Timo Guzman, Deputy Head of Delegation European Union, EU to Malaysia. Mr. Ahmad Farid Muhammad, Deputy Secretary, Climate Change Division, Ministry of Natural Resources, Environment and Climate Change. Respected speakers, we have Yang Arif Datuk Lim Chong Fong, the Judge of Court of Appeal Malaysia. Ms. Pam Adam, Sustainability Planners, Central Region Council of Government of Pennsylvania. Ms. Kwong Chiu E, Partner at Rahmat Lim and Partners, and also Partner for ESG Public Policy Practice Group and YC Lee Professional Fellow. Mr. Q Jia Yo, Bar Council Environment and Climate Change Committee. Associate Professor Dr. Maizatul Mustafa, Director of the Symposium. Participants, ladies and gentlemen. Assalamualaikum warahmatullahi wabarakatuh and very good morning to everyone. Since we are still in the month of Shawwal, I believe that it is not too late to wish you all Happy Eid, Selamat Hari Raya, Maaf Zahir dan Batin. Ladies and gentlemen, esteemed guests, respected colleagues, and my beloved students. On behalf of the Dean of Ahmad Ibrahim Kuliah of Law, I call IIUM, it is our pleasure to welcome you all to the International Symposium on Environmental and Climate Change Mediation. Unfortunately, the Dean has to attend to some urgent family matters, so he is unable to join us today. He has sent his deepest apologies and requested that I convey his best wishes and express gratitude for your attendance at this event. It is our pleasure to welcome you all to this important event that will focus on mediation and climate change. We are honored to have such a distinguished group of experts, practitioners, and academics from a variety of disciplines and sectors join us today. We appreciate your dedication to address the critical issues of climate change. We hope that today's discussion will be productive, enlightening, and that we will learn how mediation can assist us in finding innovative and collaborative solutions to the challenges we face. As we all know, climate change is one of the greatest challenges that our planet encounters today. The effects of climate change can be felt in numerous ways, including rising temperatures and sea levels, and increase in the frequency of extreme weather events. In Malaysia, we are experiencing the effects of climate change, including increased flooding, landslides, and more severe heat wave. For example, the temperature during Hari Raya in some part of Malaysia has reached 38 degrees Celsius. There is, however, hope. We can work together to discover solutions to this global crisis through mediation that would enable to bring us together, listen to one another, and work collaboratively to identify shared solutions and common ground. We are privileged to have a thriving and developing mediation community in Malaysia. We have mediators with expertise in a variety of disciplines, including environmental science and policy, community engagement, and dispute resolution. By combining these diverse viewpoints, we can develop innovative solutions to some of our nation's most pressing environmental challenges. One of the primary advantages of mediation is that it enables us to pursue win-win solutions. These days, climate change discussion become adversarial, with various groups competing for their own interests. Mediation allows us to overcome these obstacles and find solutions that address the concerns of all parties. In addition, mediation offers an exceptional opportunity for education and awareness. By bringing together stakeholders from various sectors, we can share knowledge and expertise, build relationship, and develop a shared understanding of the issue we confront. In turn, this can contribute to the development of trust and cooperation, which are essential to the success of any environmental initiative. Before I end, I would like to extend our thanks to the organizing committee headed by Dr. Maizatul Mustafa and our resource person, Ms. Kwong Chiu Yi, together with the team members for their tireless effort in ensuring the success of this international symposium. Thank you very much. Thank you also to ICOL Climate Change Policy and Law Center, CCPL, Harun and Hashim Law Center, and our collaborators, the Professional Fellow Program of Young Southeast Asia Leadership Initiative, YCLE, that it is a program of the US Department of State supported by the American Council for International Education, as well as the ICOL flagship on peace and justice. I would not want to miss also in thanking Prof. Dr. Akmal Khuzairi, who has found the time in his busy schedule to deliver the opening speech for this symposium. To conclude, I would like to thank everyone for attending here today. Your presence demonstrates your dedication to address the critical issues of climate change. I believe that this event will provide an excellent opportunity for education, collaboration, and action. We can create a more sustainable future for Malaysia and the entire world through the power of mediation. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Dr. Wan Zul Hafiz. Now, I would like to invite Professor Dr. Akmal Khuzairi Abdul Rahman to give his opening address. Falyatafaddal mashkura. Please welcome, Professor.
Thank you very much, our brother MC. Brothers and sisters, ladies and gentlemen, first and foremost, let me welcome our guest today, Mr. Timo Guzman, Deputy Head of Delegation of EU to Malaysia. Again, our colleague, Mr. Ahmad Farid Muhammad. He's the Deputy Secretary, Climate Change Division, Ministry of Natural Resources, Environment and Climate Change. Other guest of honors of our international symposium today is Yang Arif Datuk Lim Chong Fong. He's the judge in the Court of Appeal, Malaysia. And of course, Ms. Pam Adams. She's a sustainability planner, Center Region Council of Government of Pennsylvania. We talked before this, and she said that this is the first time that she's in Malaysia, and of course in this university. Welcome, Ms. Pam. Ms. Kwong Chiu Yi, partner at Rahmat Liman Partners, ESG, Public Policy Practice Group, and YCLE Professional Fellow. And Mr. Q Jiayo, Bar Council Environment and Climate Change Committee. Again, my colleague, Dr. Wan Muhammad Zul Hafiz and Dr. Maizatul Mustafa. Brothers and sisters, participants, again, good morning. Assalamu alaikum wa rahmatullahi wa barakatuh. Alhamdulillah, wassalatu wassalamu ala rasulillahi wa ala alihi wa sahbihi وَمَنْ تَبِعَهُ وَوَلَهُ. The International Symposium on Environmental and Climate Change Mediation is organized by Ahmad Ibrahim Kuliah of Laws, known by its acronym ICOL. It is to commemorate the 40th anniversary of the International Islamic University Malaysia, since this very faculty was the first faculty established with the establishment of the university 40 years ago. It is also in line with the objective of the Climate Change Policy and Law CCPL Center to support networking and capacity building that offer opportunities for interaction among key stakeholders in climate change policy. Ladies and gentlemen, the climate crisis is causing severe disruptions in lives and livelihoods. Global warming has caused population all over the world to face food and water insecurity and severe floods. The list of disasters is quickly getting longer. Climate change amplifies existing threats, worsening problems for the economy, environment, and society, which are the foundation of sustainable development. The inevitable climate change consequences on human and environment have raised the question of who should bear the risk of climate harm, whether it is the industry, the government, or the private individual. Through the 2015 Paris Agreement on Climate Change, 197 countries, including Asian countries such as Malaysia, have committed to ambitious efforts to combat climate change and adapt to its effects. Solutions are urgently needed in policy and governments to mitigate and reduce impacts which involve cross-sectoral and cross-disciplinary perspectives to develop effective policy responses. Ambitious climate actions produce new opportunities for the economy, environment, and society. But these are contingent upon international cooperation, with social justice and equity being core aspects of climate resilient development pathways. Linking the international process and national policy-making processes and developing legal strategies to integrate climate and development actions, therefore, require prompt consideration from policymakers. In some cases, countries have created new institutions and frameworks specifically for the implementation of the 2030 Agenda. In other cases, existing institutions, frameworks, and tools may be usefully adopted as part of the Agenda 2030. The Agenda 2030 strategy, such as through the intervention of the judiciary. In order to make climate change targets achievable through the reliance of legal provisions, fundamental steps need to be taken through a transformation of policy, law, and institutional framework. Therefore, this is the objective of this very symposium. It is very timely for us to achieve that aims and to look into it to address these pressing challenges by building greater competence towards a new era of cooperation and capacity building against the backdrop of deepening uncertainties. We learn from top scholars, hopefully, through this symposium, from the policy makers, from the scientists and industrial players, through dialogues and mediation, through mediation training as they share fresh insights, bold ideas, and experiences that can help stakeholders navigate climate policy and law actions in an interconnected world. The Kuliah of Law of International Islamic University Malaysia, through its Climate Change Policy and Law Center and Harun M. Hashim Law Center, is undertaking a leadership role in environmental and climate change education and also research, networking, and dissemination. The International Symposium would help to attain a cumulative buildup of social awareness and influence the practices of the corporate sector, community stakeholders, and local and national governments on climate change governance. It is the first time in Malaysia, a program which combines a high-level dialogue and a mediation training of trainers workshop on environmental and climate change mediation is organized. This symposium is organized with the support of the YSEALI Professional Fellows Program. YSEALI Professional Fellows Program is a program of the U.S. Department of State with funding provided by the U.S. government and supported in its implementation by the American Council for International Education. The main purpose, of course, of this symposium is to enhance the understanding of environmental law and climate change as an important aspect of policy decision and governance, to discuss solutions on climate policy actions at the national and international levels, and to enhance the capacity and participation in climate action, especially through mediation, and to support stakeholders interactions and networking. Thank you, ladies and gentlemen. We hope that this would be a very successful conference, and hopefully that we'll meet again to enhance our discussion and to look into these matters more seriously in the future. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Professor, for your opening address. Honorable guests, ladies and gentlemen, before we proceed with our high-level climate change dialogue, Professor Akmal Khuzairi shall take his leave from this symposium. And we would like to express our gratitude to him again for his opening address just now. I think before we proceed with that, perhaps we can have a photography session first. Oh, I see. Yes, okay. Okay, sisters, brothers, ready? Okay, ready? 1, 2, 3, one more. Ready? Sorry. Okay. Ready? 1, 2. Thank you. Members of the floor, just as a reminder before we proceed with the high-level climate change dialogue, to those who wish to leave this hall, kindly use the doors located at the back on the right and left corner. We shall now proceed with the climate change dialogue, where our learned speakers shall be Yang Arif Datuk Lim Chong Fong, Ms. Pam Adams, Ms. Kwong Chiu, and Mr. Q Jayao. This dialogue will be moderated by our Associate Professor, Dr. Maizatun Mustafa, where her expert areas are environmental law, climate change, and sustainable development. She obtained her LLB degree and MCL from IIUM. In 2001, she acquired her PhD from School of Oriental and African Studies, University of London, United Kingdom. She is also currently the coordinator for CCPL Center, ICOL, and currently leading a research grant with Erasmus on climate change, law, and policy. In 2022, Dr. Mazatun had published the 5th edition of her book entitled Environmental Law Malaysia with Walter Scluer. In 2020, her book project on climate change litigation with the National University of Singapore and Yale University has been published by Cambridge University Press. While in 2017, she was appointed as a trainer to train legal and judicial officers on the international response to climate change. She has also been appointed by the Chief Judge of Sabah and Sarawak, Malaysia, as an advisor to the Preparation Committee Environmental Court Rules. At the international level, she is an active member of the International Union for Conservation of Nature, IUCN, Academy of Environmental Law, and the IUCN World Commission on Environmental Law. I shall now pass the floor to our moderator. Please, Dr. Maizatun.
Thank you so much, Mr. Chairperson. Assalamualaikum warahmatullahi ta'ala wabarakatuh, and good morning, everyone. Mr. Timo Guzman, Deputy Head of Delegation EU to Malaysia, Encik Ahmad Farid Muhammad, Deputy Secretary, Climate Change Division, Ministry of Natural Resources, Environment and Climate Change, Malaysia, Assistant Professor Dr. Wan Zul Hafiz, Deputy Dean Academic and Internalization, representing the Dean of ICOL, respected speakers. We have here Yang Arif, Dr. Lim, Ms. Pam Adams, Ms. Kwong, Mr. Q, participants, ladies and gentlemen. Welcome everyone to this high-level climate change dialogue. Can you hear me quite well? Okay. Right. I have the pleasure to serving you as moderator. The Paris Agreement increases the necessity for countries to review its institutional and policy setup on climate change. Malaysia has indicated that it will reduce its greenhouse gas emissions intensity of GDP by 45% by the year 2030. The greater burden on Malaysia to address climate change under the Paris Agreement means that the country has to strengthen its institutional and policy framework on climate change. The lack of know-how in formulating integrated development and climate actions and in exploiting the win-win options remain serious barriers, leading to significant gaps between the formulation and implementation of effective climate change policies. Interdisciplinary skills and expertise are required to acquire in-depth theoretical and practical understanding of the evolving environmental legal system and in order to formulate robust policies. Ahmad Ibrahim Kuliah of Laws has been undertaking a leadership role in environmental law and climate change education, research, networking, and dissemination. In 2021, we managed to secure the EU Erasmus grant on climate change policy and law to enable us to set up a center known as Climate Change Policy and Law Center. And at present, we are designing and introducing a curriculum for the master's degree in climate change policy and law based on the integration of multidisciplinary educational program. Through our climate change networking and dissemination initiatives, we managed to engage with various stakeholders locally and internationally. Indeed, this international symposium is organized with the support of the YCLE Professional Fellows Program, which is a program of the US Department of State supported in its implementation by the American Council for the International Education. Thank you so much. The theme for this high-level dialogue is navigating the terrain between global and national policies and strategies on climate change. Environmental law and climate change are now crucial aspects of policy decision-making and governance. This high-level dialogue is meant to enable participants to learn from legal fraternities. We have judges here, we have legal practitioners, policymakers, and industrial players as they share fresh insights, ideas, and experiences that can help stakeholders navigate climate change policy and law actions and its interconnections. This high-level dialogue is also meant to enhance the understanding of environmental law and climate change as an important aspect of policy decision and governance, and to discuss solutions on climate policy actions at the national and international levels. We are fortunate to have with us today 4 eminent speakers from different backgrounds who will share with us their views, ideas, and issues relating to climate change policy and law. Everyone, there will be 2 sessions of this high-level dialogue. The first session is for each speaker to speak on a specified topic. Each speaker will be given about 15 minutes to speak for their topic. After all the speakers have presented, the second round is for the question and answer session. Each speaker will be answering 3 questions which we have prepared for them, and they would be given a few minutes to share their answers. Let me start with introducing our first speaker, Young Arif, Datuk Lim Chong Fong. Let me read his profile. Justice Dr. Lim Chong Fong has a Bachelor of Science Building Honours degree from the National University of Singapore, a Bachelor of Laws Honours degree from the University of London, and a Master of Laws degree from the University of Malaya. He is a chartered arbitrator, chartered quantity surveyor, and barrister at law Middle Temple. He has worked as a quantity surveyor in the construction industry and practiced as a construction lawyer and arbitrator from 1985 to 2013. He was ranked as a leading lawyer in construction dispute resolution by Chambers and Partners, Asia Law Profiles, and the International Who's Who of Construction Lawyers Legal Directories. We have more. He has undertaken research on the security of construction payment as a Fulbright Scholar at the William S. Richardson School of Law in Hawaii, USA, and was subsequently appointed by the Construction Industry Development Board Malaysia to formulate the Construction Industry Payment and Adjudication Bill, now Act 746 of Malaysia. He was the Honorary Advisor Contracts of the Master Builders Association Malaysia and was appointed by the Ministry of Works in 2013 as a member of the expert panel to review the Malaysian construction industry practices following the construction accident at the Penang Second Bridge project. In 2017, he was awarded the Lifetime Achievement Award Quantity Surveying by the Royal Institution of Surveyors Malaysia. Justice Dr. Lim was appointed as Judicial Commissioner in January 2014 and confirmed as Judge of the High Court of Malaya in January 2017. He has served the General Civil and Criminal Courts as well as the Specialist Intellectual Property and Contraction Courts. Recently, in January 2023, he has been appointed as the Court of Appeal Judge and presently serving the Court of Appeal in the Palace of Justice, Putrajaya, Malaysia. Young Arif Datuk Lim will be speaking on climate change litigation in Malaysia. Please welcome Young Arif Datuk Lim. Datuk, you can choose whether to sit down or to use the restroom. All right, thank you.
Dr. Wan Muhammad Zulhafiz, Deputy Dean Academic and Internationalization, ICOM UIA. Mr. Timo Guzman, Deputy Head of Delegation, European Union, EU to Malaysia. Yang berusaha Encik Ahmad Farid Muhammad, Deputy Secretary, Climate Change Division, Ministry of Natural Resources, Environment and Climate Change. My learned panelist, Ms. Pam Adams, Sustainability Planner, Central Region Council of the Governments of Pennsylvania, Ms. Kwong Chiu-Yi, Partner of Rahmat Lim and Partners, and Partner for ESG Public Policy Practice Group, and Sealy Professional Fellow. And Mr. Q Jia Yo, the Bar Council Environment and Climate Change Committee member, and Associate Professor Dr. Maizatun Mustafa, the director of our symposium this morning. Ladies and gentlemen. Good morning to all. First and foremost, I wish to thank the Ahmad Ibrahim Kuliah of Laws, Climate Change Policy and Law Center, and Harun M. Hashim Law Center of the International Islamic University Malaysia, in collaboration with the Young South East Asian Leadership Initiative Professional Fellow Program under the US Department of State, for inviting the Malaysian judiciary to participate in the high-level dialogue of this international symposium on environmental and climate change mediation 2023. I am truly honored and privileged to be nominated by our Honorable Chief Justice to represent the Malaysian judiciary here this morning. The judiciary is generally regarded as the third arm of the Malaysian government, and the Malaysian courts play a crucial role in protecting human rights. The protection of environmental rights that include issues related to climate change is without exception. The specific roles of the courts in relation to environmental protection and climate change include: 1. Interpretation and application of environmental laws and regulations. 2. Enforcement of environmental laws and regulations, and to hold individuals and corporations accountable for any violations. The measures include imposing fines, ordering the closure of polluting facilities, and even imprisoning individuals who violate environmental laws. 3. Judicial review and scrutiny of governmental actions relating to environmental protection and climate change that include decisions relating to environmental impact assessments, permits, licenses for development projects, and other governmental actions. And 4, setting legal precedents on environmental and climate change through case laws which may shape future environmental policy. The Malaysian judiciary has been sensitive to the public need for protection and enforcement of environmental rights. The enforcement of these rights in the court may be in the form of criminal prosecution for contravention of statutory laws and regulations, or civil litigation premised on tort law causes of action, such as negligence, breach of statutory duty, nuisance, and the rule in Rylance versus Fletcher. Towards this end, the Malaysian judiciary has on the 27 August 2012, via the Chief Registrar Practice Direction number 3 of 2012, established the environmental courts. These environmental courts comprise of dedicated magistrates courts and sessions courts clothed with criminal jurisdiction set up in every state throughout Malaysia. Furthermore, the Malaysian judiciary has on the 22nd of March 2013, via Chief Registrar's Practice Direction 2 of 2013, assigned the specialist construction courts housed in the Kuala Lumpur and Shah Alam High Courts to hear environmental pollution civil cases in West Malaysia. However, the courts will only be brought into action if there is enforcement of environmental rights. As for statistics of the environmental courts in the past 6 years, the magistrate courts dealt with a total of 1,316 cases, including 111 carried over from the previous years, and disposed 1,313 cases, leaving 3 cases brought over to this year. Likewise, the Sessions Court dealt with a total of 4,893 cases, including 113 carried over from the previous years, and disposed 4,623 cases, leaving 270 cases brought over to this year. There were 204 cases, including 3 from the previous years, appealed therefrom to the High Court, and 182 were disposed, leaving 22 cases brought over to this year. There has not been any pollution case instituted in the Specialist Construction Court to date. I was in fact looking forward to encounter one when I served in the KL Construction Court from 2019 to 2022. Now, as for climate change, I understand the lay definition as probably the profound alteration of weather conditions that affect life and livelihood. But I've also researched into Google, and there seems to be a scientific definition. That is that it's a long-term increase in Earth average surface temperature, which results in weather patterns change caused by largely greenhouse gases emission, particularly from the usage of fossil fuels. I've researched the internet, and it's interesting to refer to an excerpt of the article entitled "Climate Change Litigation, a Possibility for Malaysia," written none other by Prof. Dr. Maizatun Mustafa, which is published in the Cambridge University Press If I could just quote the excerpt, quote, while there has been global advancement in climate change litigation, even among some developing countries, this is not currently the case in Malaysia. Even though Malaysia has shown its commitment to mitigating climate change by passing legislation and executing various policies relating to climate change, there has not been a single case brought to court on this issue. This situation is not surprising, considering that environment-related lawsuits are still lacking, with only a small number of environmental cases ever been decided in Malaysia. While the litigious culture is not common among Malaysian society, factors such as the state of the judiciary, limited access to justice, limited environmental awareness, and limited recognition of environmental rights have further undermined litigation in the area of environment and climate change, unquote. With respect, I believe the Malaysian judiciary is ever ready and willing to deal with climate change and other environmental litigation, especially in the specialist instruction court that have all been set up. Access to justice in terms of court fees is actually very affordable to just as in the same as in the other types of civil litigation. It's actually not costly. The court fees are very, very reasonably priced in this country comparatively. The limitations, in my personal view, are more likely due to several other factors. Firstly, there is the extraterritorial jurisdictional problem. Say, for example, the annual haze pollution that is suffered here, but emanated from neighboring Indonesia. As far as I know, there has not been any litigation that concerned the haze problem to date. Secondly, there is the problem of proof of the tort, as can be seen in the well-known US groundwater contamination cases against W.R. Grace and Co., made into the movie A Civil Action, acted by John Travolta, and against Pacific Gas and Electric Company, made into the movie Erin Brockovich, acted by Julia Roberts. And thirdly, I agree with Dr. Maisatu that there is limitation of awareness of environmental rights amongst Malaysians. I may add that Malaysians are generally rather tolerant and non-litigious too, unless it concerns a life or death issue. Finally, I acknowledge that development of environmental law, or rather case law, by the Malaysian courts is still presently in its infancy. Nonetheless, I believe this will progressively grow with civil litigation resulting from better public awareness of environmental rights, particularly through pervasive implementation of environmental, social, and governance, ESG, sustainability concerns nowadays. And with that, I thank you all.
Thank you so much, Young Arif, Datuk Lim. Datuk, I was overwhelmed just now when you quote from my writing. I mean, just imagine you are a federal court judge quoting from my writing. I think you can make my day if you can quote in your judgment my writing. Can you do me a favor? Yeah, I was quoted before by the Chief Justice previously in his speech, previous Chief Justice. So that made my day as well. But now, I mean, in front of everyone, wow, thank you so much for that, Dato'. Yeah, well, Dato' was talking about the role of judiciary, about environmental court in Malaysia. And then, of course, it's not that he just quoted from me, but there are some point where he agree or maybe slightly disagree about the payment of litigation in Malaysia. And then you're talking about the extra territorial jurisdiction problem, like the haze, transboundary haze problem. This is a continuous problem in Malaysia. I have one student doing her thesis on this, on haze, his problem, because the law is one thing. I think Jaya also working on this previously. And then you talk about the problem of evidence and so on. Perhaps later during the Q&A, you can elaborate us more on this. Now, maybe I can go to our next speaker, which is Ms. Pam Adams. Let me first introduce Ms. Adams. Pam Adams is the Sustainability Planner at Santa Regional Council of Governance, CRCOG. She prepares, monitors, coordinates, and provides direction for the implementation of the Santa Regional Climate Action and Adaptation Plan, CAAP. Working collaboratively with municipalities, CRCOG, agencies, and other community stakeholders, she assists with policies, programs, and initiatives that promote local environmental, energy, economic, and social sustainability. Prior to June 2019, she was CRCOG's refuse and recycling administrator for 11 years. Pam graduated from Penn State University with a Bachelor of Science in Industrial Engineering. Ms. Pam Adams will be speaking on climate change mediation. Please welcome Ms. Pam Adams. It's up to you.
Selamat pagi. It is an honor to be here today. This is my first time in Malaysia, and this is a beautiful campus. And from what I've learned from the video, I feel like I'm at a very progressive and role model university at IIUM. You seem to be taking a lot of leadership roles in sustainability. So thank you for that. And I'm really excited to be here. So again, it is an honor. So I come from Pennsylvania, which is on the eastern side of the United States. We're about 4 hours from New York City and 4 hours from Washington, D.C. So you might have heard of those places. I come from State College, which is where Penn State University is housed. This whole reason that I was able to be here is through the YCLE Fellowship Program. Chewy visited last summer for a month at our town in State College, and there was lots of collaboration between the university and the program. I work for local government, and so what has happened is I, in 2019, was asked by our elected officials to create a climate action and adaptation plan and identify actions that can be taken through policy as well as by community members so that we can meet our target goal of reducing our greenhouse gas emissions 45% by 2030. So this is a very localized program that supports the global initiative of reducing emissions and combating climate change. During a presentation with a NGO, I met Professor Laura Fowler, who is a law professor at Penn State, and she has done a lot of mediation. And she views mediation as not necessarily a conflict between one and two parties, but also as a way to help develop creative solutions to complicated problems. So today I have some background in mediation courses. I've taken a couple classes, I've participated, but I am not a lawyer. I come to you today giving you sort of the perspective of a policymaker on how mediation can be beneficial to the community. And as you've heard from everybody who's gotten up here, and you probably know, climate change is a very complicated problem. As the judge pointed out, they're taking it to the court for a solution is very complicated when the haze or the pollution is coming from actions from years ago, right? Climate change is complicated. It also affects everyone, and it's going to affect people differently. And what happens is that we all have different levels of understanding of it. If you look at it from a global perspective, we all understand it and view it differently. While there are many solutions out there that we know that we can take, there is not just one easy solution. Again, it's a complicated, complex problem. But we also aren't taking enough action quick enough to meet our goals. We know there are things, some of us know there are things, a lot of us know there are things and actions and policy that should be happening, but it's not. And why is that? It's bogged down in conflict. People are starting to take positions, and once people start having positions, then that conflict grows. People are taking sides. Everyone has a different view of what public good is. So when you sort of break this down and you can look at things, the complexity is twofold, right? It's the system piece of it. We have to look at things different from business as usual, and we need those major shifts to happen. That means getting outside of our silos and our different ways of doing things. And so it's going to be the technology and the science is being driven from universities and from subject matter experts doing the research on here are the solutions. And when you're at a university, you can do things in the lab and you can run things through paper and it works. But the other part to this, the second part of this complexity is the human dimension. And universities and more of us are understanding like the technology and science side is maybe the easier side. This human dimension piece is where we're starting to understand how important it is, because you can't just make these things happen. Changing the human behavior is very difficult. I think all of you are here today to learn and to listen, but we all can do things and need to do things that will be difficult and make us change some of our ways. But we don't want to be overwhelmed by it, and we have to remember that small steps lead to progress. So we need that human dimension part to be intertwined and related to the science and technology part. So it's more of the science technology folks are learning that we need people from humanities and social sciences and the other departments in the arts department to help us understand and reach more people in our community. And really, that's the definition of sustainability, right? Like we need to break down silos, look at the economic, the social, and the environmental aspects intertwined. You can't just look at one without the other. And I always am a big fan of the United Nations Development Goals that hopefully you're all aware of, because I think they lay out really how everything is intertwined and connected. You can't just look at climate action without looking at poverty, without looking at peace and conflict. So that those all intertwine together. So at a local government level, when we're looking at policy, we could just write new laws and set policy, but will it work? If you're in a divided community and you haven't educated and spoken to your stakeholders, it's not going to work. You'll get voted out the next round of elections, and you'll have more controversy probably than positive path forward. So it's really about making sure that you're reaching out to your community, which again is how I connected with Laura Fowler, the professor at Penn State, to create this class, a course within this with the students' help to be able to work through mediation with stakeholders in our community. And what we really wanted is to make sure people felt heard. If people believe that their message is being heard and that it's fair and transparent, they might not like the all of the policy projections and rules, but they'll also accept them. So that is part of the purpose of mediation. We really felt that we needed to bring people and the stakeholders to the table to be part of the conversation. Now, I will say that not all of the stakeholders come to the table, but we had multiple ones that do. And even if you get, so for example, we're looking for developers, the people who are building the buildings. We want people who are the major thought leaders of our community, the NGOs and some of the organizations that are truly passionate about this. They showed up, but we're trying to reach a diverse group. And if you just get a few of them in the room, then they can go back and speak to more of their partners. Me as local government was not the best for bringing people to the table. But the beautiful thing about the university is that the students were a neutral party. So being able to present things and be able to talk through things as the mediators through students was very beneficial to us, because the different businesses, different organizations have a trust in government and others don't. But at our community, the students sort of have a superhero power that they can ask questions and be forgiven if they, say the wrong things. So having the students be part of this program was very important. What we wanted to do was to make sure that people felt like their voices were heard, that they'd have a better understanding. Again, it's really about trying to help people have not the same understanding, but to understand what the purpose of why we were taking action, and really trying to make it relatable. I've heard about some of the issues that climate change is bringing to you, and in Pennsylvania, we have a different set of those. It's still similar. We have heavy precipitation, extreme rain events, but we're at the headwaters of a river of the Chesapeake Bay. So we have more nuisance flooding than major flooding, but we also have an obligation to make sure at the headwaters that we're doing things right for our neighbors downstream. But we have also a lot of agriculture. So for us, that is something that will be impacted by these extreme rain events. But when you localize the problems, then it helps the stakeholders realize that it's going to impact them, right? If you're talking so broad, people may be able to push it down the road. But when you talk about the problems that we're having, we've had roads that have been damaged and washed out. So then communities have to, drive an extra 45 minutes to get to their places of work. So those types of conversations are really important to localize what the problems are. And part of these climate conversations that we've been having through this course is to make sure people feel like we're all in this together and that they can be part of the solution, because we don't have all the answers. And while we can lay some of them out and be able to provide them, if the community isn't going to support it, then the policy won't work. So it's very important to have that connection. And by building some momentum, by having some small successes through this mediation process of open dialogue, then it can lead to more progress. So if you set some policy and people understand it, then they'll be more accepting of the larger one, which also helps in the global and national sense. Then people, if they can understand it locally, can hopefully understand it at a larger scale. So mediation can really accelerate the creation of productive relationships and also provide those innovative and lasting solutions. And again, it's really trying to create that open space to share experiences and values, because when people of different types of different stakeholders come together, they all come to the table with their position, with their interests, what is valuable to them. And it's important to be able to exchange arguments in a safe place based on reason and feel heard. And you want to be able to consider different viewpoints. And then once you're able to do that, you can recognize the trade-offs inherent in every approach. So by coming to the table and listening to others and having a mediator being able to provide that place where everybody gets to have their voice heard, you can start to understand that there isn't one solution. Your solution is probably not going to happen. You have to compromise, and that jointly you can come up with some trade-offs. There's always some ways to compromise. So really mediation, the way I view it, is a cooperative approach to managing disputes. And it can be ahead of those disputes is what we'd like to see it. And that is why in the process of creating a climate action plan, we worked through this mediation process with our community to help form our climate action and adaptation plan. So we have a set of 82 actions that we need to take, and it was adopted in November of 2021. So it is different from a judge or an arbitrator decision, where the mediation uses a third party. It's a neutral party that can bring the people together. It does not render the decision. So the mediator itself doesn't make the decision where the judge does. The mediator does not instruct the stakeholders on how to resolve the solution, but walks them through the process. So it allows stakeholders to retain control over the process and the outcome. So it's really empowering to the stakeholders to feel that this was a group decision. And so it's great to be having this conversation at the university today, because working with students to be able to build and train more mediators and facilitators, I think is really key to having this complicated climate change problem solved. We need more mediators, more people who understand the importance of this open discussion. So through this course at Penn State and maybe future courses here at IIUM, students and becoming mediators, or even if you're not intending to be a mediator, you can understand the process so that you can learn the coordination of the process for negotiation. You can learn how to form these constructive conversations, know ways to decrease tension, right? So if you're bringing people to the table, there's going to be tension, and that is okay. It is part of the process to get to the final solution. But a good mediator will know how to de-escalate the problem so that people can continue to work together. And really being able to frame the issues from a more balanced perspective, right? We don't need to take sides if we want to be able to find a solution, because both of those sides really have some areas where they can come together, and that's what the mediator needs to help find. So really, if you look at like the technology and advancing the solutions for climate change and the human dimension, that mediation can be the bridge to join them together. So thank you.
Thank you so much, Pam, for your insightful presentation. Everyone, actually this afternoon, there'll be a mediation training for trainers by Pam. So we really look forward to that, but just let us recap. Are you? Mr. Timo Guzman is leaving soon. Okay, thank you so much for coming, Mr. Timo. Hoping to see you again very, very soon. Let me just recap what Pam had said just now. Okay, I really like what you said about mediation to create creative solution to complicated problems. Indeed, climate change is a complicated problem, and you also talk about climate change on human as a human dimension issue, or you speak also about policy that need to be reached out to society, and then that people need to be heard so that they can feel part of the policy itself. And then I really like when you mentioned about the role of university, the role of students as a neutral party in mediation. You talk about localizing the problem. You also mentioned about exchange of arguments based on reason and to recognize the trade-offs. Compromise is the key word. When we talk about environmental issues, when we talk about sustainable development, maybe some of my students here, you can remember what I've been talking about, that sustainable development, in theory, it looks so nice because it seeks to balance both environment and development. But in reality, how do we balance that? How do we balance the different needs of a society? How do we balance the need of ourselves, for example, for peaceful, whereas our neighbor might want to renovate his or her house? I mean, we're talking about just between neighbors. How about we're talking about in a community, a larger community, and so on? So the balance is like sometimes the parties not just two parties. It can be more than two parties, and all of each parties have their own needs and interests, which is valid from their own perspective. So we're talking about trade-off, we're talking about, compromising. So we really look forward to this afternoon session with you. We will have few questions to ask you later, Pam. Before that, I will move on to the next speaker. The next speaker will be Ms. Kong Chiu Yi. Let me introduce her. Let me read her profile. Kong Chiu Yi is a dispute resolution partner at Rahman Lim and Partners. She is also part of the firm's ESG and public policy practice. Chiu Yi was admitted as an advocate and solicitor at the High Court of Malaya in 2012. You are so young. I feel so old. She graduated from the University of London. Which University of London? Okay, all right. Because, okay, I did my PhD there also, yes. And you also, Dato', right? Okay, alumni here. With a Bachelor of Laws Honours degree in 2010. She also holds a Master of Law from the London School of Economics and Political Science. In 2022, Chiu Yi was selected as a Young Southeast Asian Leadership Initiative Professional Fellow, Sustainable Development and Environment Institute theme, a fully funded leadership and professional development exchange program sponsored by the US Department of State Bureau of Educational and Cultural Affairs. She is the National Rapporteur of Climate Change Litigation at the Sabin Center of Climate Change Law at Columbia University, and a National Consultant of Environmental Law at the United Nations Environmental Program, where she is working on reviewing the national regulatory regime on waste trafficking and wildlife trade. Chiu Yi was included in the Asian Legal Business Asia 40 Under 40 list, which profiles the most accomplished lawyers in Asia under 40 years of age. Yes, you are indeed very young. Under 40. Cannot remember when was that in my life. She was also listed in the Asia Legal Business Rising Stars Malaysia List 2022, which showcases Malaysia lawyers under the age of 40. You keep on repeating that. I'm just reading what you wrote. Currently doing high quality work and earning accolades from their clients. Ms. Kong will be speaking on the roles of ESG, environment, social governance in climate change mitigation. Please welcome Ms. Kong Chiu Yi.
Thank you. Thank you, Dr. Maizatun. And I'm indeed very young, which is why I'm a Young Southeast Asian Leadership Initiative Fellow, which is the program that is supporting the today's event. I must say that usually when I appear before a judge is in court, so the feeling today is very different. So I'm not as nervous. So I'll be speaking about the role of ESG in climate change mitigation. So I'm sure most of you, if not all, have heard of these three letters ESG. Now, ESG refers to the three central factors in that businesses are using to measure the sustainability and societal impact of their business operations. So it's environment, social, and governance. Now, increasingly, we're seeing that these three factors are taking center stage in business and investment decisions. And they allow us to integrate long-term sustainability and ethical concerns into the very heart of business and investment strategies. And in doing so, we can then use businesses as a powerful tool in our fight against climate change. Now, let's look at the first letter in ESG, E, which stands for environmental consideration. Now, this refers to how a company interacts with the natural environment. So, company exists together with natural persons, so they interact with the natural environment as well. So when it comes to ESG, we have to look at how companies use their energy, how their operations resulted in waste, how they manage waste and pollution, and also conservation of natural resources. The focus of ESG is actually to direct investments either through shareholders or funding in businesses, to companies or businesses that are more aware of environmental issues, that are ready to minimize their environmental footprint. And we as consumers, for example, can incentivize businesses and the market to move towards sustainable practices. And herein lies a powerful weapon of ESG against climate change. But that's not the only aspect of ESG as a tool to towards climate change mitigation. It is also used as a tool to encourage businesses to understand and manage risks of climate change to their businesses. Now, so many businesses may not be aware, but actually climate change do pose significant risks to businesses. So there are generally two types of risks. First, we call it physical risks. These are where extreme weather events can actually disrupt supply chain as well as damage business infrastructure. So climate change impact businesses financially from that aspect. Then there is also something that is not very overt. We call that transition risk. So we're looking at especially young people being more aware of environmental and climate change issue. And this may actually result in transition risks to businesses, because consumers, the younger consumers, tend to avoid companies or businesses that are not environmentally friendly. So incorporating ESG factors into investment decision allows businesses to better manage their risks. So the other aspect that we're looking at for ESG trend is that investors can actually wield significant influence over corporate policies. Now, those who are of the older generation might have heard of this free market economy philosophy, that the only objective or the only purpose of a business is to make money for their shareholders. So it's to maximize shareholders' value. So we're looking at changing the mindset of businesses, that maximizing shareholders' value do not mean just monetary profit, but it's also it also includes preserving the value of the company in view of the risks of climate change. So from that aspect, investors and shareholders can actually wield very important influence over corporate policies. So they can push for greater transparency, can push businesses to reduce their greenhouse gas emission, better resource management. And in fact, if we're looking at EU or even in the UK and the US, there's a move towards what we call shareholders activism, where shareholders are taking active steps to force businesses to look into sustainability issues. Yeah. So how about the S and G? Because S refers to social and G refers to governance, right? So some people see these three, E, S, and G, as being independent, but my view is that they are actually quite well connected to each other, and they are connected to environment, the E aspect, in various ways. So social and governance, so it goes into the company's culture and values. So if a company has a strong social and governance practices, it is more likely to have an organizational culture that values ethical and sustainable operations, which also naturally will extend to environmental responsibility. So for example, a company that prioritizes employee well-being, I think they're more inclined to focus on minimizing its the environmental impact of its operations, because if the business, the operations of the businesses result in adverse environmental impact, so it will affect the local community of which their employees are part of. Yeah. So it also forms part of the long-term business strategy of the company, like I mentioned just now, to incorporate environmental considerations in their strategy. So that's part of governance. And companies that have very good governance will routinely engage with their stakeholders, including employees, customers, and communities. and will more likely consider environmental impact of their operations. So you also have social considerations such as community relations and customer satisfaction that actually go hand in hand with environmental responsibilities. And of course, supply chain responsibility. So from an ESG perspective, it is not sufficient that you ensure that your own company's operations are sustainable, but everyone at the below your supply chain, your suppliers, you must also ensure that they adopt sustainable practices. So in conclusion, the integration of ESG factors, as we see to businesses now, it is a very important tool to combat climate change. So when companies and investors collectively prioritize ESG, it sends a powerful message to the world at large and to businesses that they must act responsibly, not just for their profit, for their bottom line, but also for the good of the planet as a whole. Because if we do not have the earth, then there is no business for you to profit from, essentially. Yeah. So I mean, to summarize how ESG contributes to climate change mitigation is this: one, it creates ESG opportunities where businesses, where environmentally conscious investors and consumers will invest or will buy from ESG compliant businesses. But it also creates litigation risk in the form of financial risk and reputational risk, which will then which have actually led to companies being more progressive in their sustainability policies. Yeah.
Thank you very much, Chui, for your presentation. The way you presented make us, easily understand what is ESG about. Let me just recap what you presented just now. You mentioned about how a company interact with a natural environment, and then that the company previously we talked about what the company want to achieve, which is profit, and whereby other things are maybe secondary. I think can I say that ESG is like a development of CSR, corporate social responsibility? Or maybe I ask that question later. Maybe I just recap that. Yeah.
Yeah, I mean, want to answer that.
Yeah.
Really, it's quite a communication effect because we have been on CSR for so long, right? And then now we have ESG, or is ESG just CSR, right? So it's not because when we talk about ESG, there's a specific matrix, specific standards that businesses are expected to achieve. Whereas CSR is more like a voluntary work, to show that, we are cleaning the beach.
Yeah.
So it's actually quite different. Yeah.
Wow. Because I always thought that it is just a repackaging. Because I want to pick up more points where you mentioned about shareholder activism, and then which forces the company to look at sustainability. It's not just the shareholders, perhaps even the consumer. When we have consumer who have high tendency, not just young. You mentioned just now about transitional risk of young workers. Even for consumers, if we have a society which is very much serious about environmental rights, they perhaps will choose product that is done through environmentally friendly processes. Or there are certain product, like I do not know whether I can mention the name positively. Body Shop, everyone recognize Body Shop. What color is Body Shop? Is green. Okay, why we are attracted to Body Shop? Because of the tagline, it's not tested on animal. And then there is, perhaps for Malaysian, you might be familiar with this particular advertisement. There is one oil and gas company that will do a very nice advertisement during every festivals like Hari Raya or Eid. Okay, this oil and gas advertisement, we will be waiting to watch the advertisement. Petronas, if you're familiar, why Malaysian would be drawn to Petronas advertisement? Are they selling their product? No, they're not selling their product. what they are selling is that they are selling their image. You see, there is one oil and gas in Malaysia where every time like Christmases, they will have this advertisement where they will show very nice, like a family or friends mingling around. You know, you have these feel-good factors. They're not selling their items at all. They're selling images, they're selling feelings. So we are drawn to that, forgetting that, well, from environmental perspective, they are the one that is causing a lot of environmental harm from the very beginning, from the offshore or onshore up to the emissions of, you know, gases from motor vehicles. So that's the thing when we talk about, you know, CSR or ESG in a company. Well, I spoke too much already. Now, can we move on to our last and final speaker, Mr. Q Jayao? Let me introduce himself. Mr. Q is a sustainable development lawyer. He serves on the Bar Council Environment and Climate Change Committee, which works on environmental justice and climate change. He is the co-chair of the Malaysian CSO SDG Alliance, a network of more than 80 civil society organizations whose work relate to the United Nations Sustainable Development Goals. He is also a resource person of the All-Party Parliamentary Group of Malaysia on the Sustainable Development Goals, APPGM SDG, which presently works with 84 parliamentarians across the political divide, with more than 250 SDG-related projects across Malaysia. Mr. Q advises policymakers, law firms, government, business, and non-profit leaders and social entrepreneurs on a range of issues related to sustainable development. Recently, he was elected as a fellow of the Academy of Sciences Malaysia. Mr. Q will be speaking on handling climate change disputes in Malaysia. Please welcome Mr. Q.
Thank you so much, Dr. Maizatun, and thank you so much to the organizers for curating and organizing this wonderful event. I think it's very interesting on so many levels, and I also appreciate that the speakers from the judiciary, from Pennsylvania, from various other places have come together in response to the invitation so that we could come together and have a dialogue and build on how we each think about climate change and the challenges that it presents. So I'm tasked with talking about contributing to this dialogue from the angle of handling climate change disputes here in Malaysia. And so I, of course, will be building on the wonderful groundwork that's been laid by all the speakers before me. So my task is much easier now, but I'll try to sound cohesive because there's so many important strands that have emerged from our discussion. So the problem of climate change, we've heard about, so I'm from an analytical perspective, I'm just saying that can we just think of it as there are two types of problems relating to climate change. One would be the impacts of climate change. So that's the flooding, the sea level rise, the extreme weather. And then on the other aspect, there would be the causes of climate change. And that would be essentially our unsustainable patterns of consumption and production, our reliance on extremely harmful or inefficient ways of living, and our ways of arranging society according to economic systems that are underpinned by clearly wrong assumptions about what the world is like, and also cultural beliefs that we have, which we have translated into norms of business, norms of accounting, and norms of law around the meaning of life and around our relationship with one another. So two parts like that. So climate change is a multifaceted problem, as we have heard. So from this the impacts side and the root causes side, all manner of disputes will arise, right? So from the impacts side, there will be disputes that will happen beyond what we can imagine right now in terms of, so me speaking as a person who works in the area of climate change, but there would be climate change related disputes, for example, on claims between someone whose house is constantly flooded and is trying to claim against his insurance provider for that harm. That too is a climate change related dispute, except will it be picked up by our Department of Statistics as a climate change problem and therefore underreported or underrecognized as a lived reality, and therefore resulting in the lack of solutions towards that type of problem. And so there will be countless instances of that on the impacts side. And disputes around the causes of climate change. We have seen a proliferation of climate change cases. So cases brought under the banner of climate change, right? And we've seen cases in the Netherlands by Agenda. We've seen cases in various places in Scandinavia, brought in case in the court of Lahore in Pakistan a few years ago, and various places. We've also had the cases brought by the young persons in Australia against the renewal of a coal power plant by the Minister of Energy in Australia. So there are lots of examples. And so all manners of disputes have arisen, and more will come. And in that lens, how we as a civilization and how we as a country are able to face, manage, and resolve these disputes is key to the quality of life, is key to decency, is key to dignity. If we do believe in living in a society and having a future in which we leave no one behind, even as we work towards improving our own lives, within the way that we have designed our societies, broadly speaking, capitalism has become the way in which we are running our lives. That's how we produce things. That's how we meet our needs. Capitalism has brought a lot of progress. It has had the effect of strengthening democracy, but we also see that capitalism can exist without democracy. We've seen a Chinese version of strong and exponentially growing economy. So that's a different version. So so I think the key thing, and I think everyone understands as well, is the social structures, the social constructs, like how an economic system should work, how a legal system should work, how disputes should be resolved, are all our collective stories in our heads, and we can then improve on these stories and thereby improve on these systems according to what we want and what we believe in and what we want to be as persons. Right? We want to be better. As we know better, we want to be better. And I think that we can see in stark contrast as we look at the generational attitudes to climate change. Just maybe about 3 years ago, 5 years ago, adults in the room would have been complaining about the millennials, about how they are demotivated. But increasingly, we are not hearing that complaint anymore. And increasingly, in global institutions, in Malaysian institutions, we are seeing a welcoming of youth perspectives, a validation of youth perspectives. And essentially, I think our identities are not defined by our age. Chiu-Yi's youth isn't an achievement in itself, it's what she has done with her time. And someone senior doesn't deserve merits just because you've passed more time than the rest of us, but really it's what you do. And I think the question of what we do should then inform how do we deal with disputes. And I think then I want to say the next important question is, what should be our North Star in resolving disputes? Pam talked about how when stakeholders come together, a compromise always has to be made. And I would like to build on that to say a compromise has to be made from each stakeholder's point of view. But as a community, we are getting to a better and better quality solution. And so there is an improvement. But from a narrow point of view, there is a compromise. It looks like a diminishing of your interests. But when you just step back and look around the table of the other stakeholders, you will see it is an improvement in the quality of the decision, whatever that decision is moving towards. And I think this is that realization of our common agenda, which is the title of the United Nations Secretary General's 2021 publication on where we stand in terms of progress along sustainable development. So the good news is we already have a North Star. We already have common blueprints agreed among all the civilized countries. And that's most of the countries, right? So we have, for climate change, we already have the UNFCCC. We've made a lot of progress in terms of all the COPs that we've done. We have got the United Nations Sustainable Development Goals, the UN, that's also called the UN Agenda for 2030. We've also got the human rights frameworks, right? The Universal Declaration of Human Rights. And as a part of that, we've also got the United Nations guiding principles around business and human rights. All these and many more are collectively our heritage. These lay out the blueprint for the better life. And it doesn't mean that the better life is defined by folks at, internationally, by, people with blonde hair and blue eyes. And no, these are all consensus rich decisions. These were all made with all the countries' participation and hard work from multidisciplinary experts from all over the planet. And that, in that sense, that's why this is like our civilization's heritage. And that is it's like the best blueprint we've got, right? They are not great, but they're the best blueprint we have as a framework for us to think about the problems that we are encountering in our respective local places, because those are unique to the communities where these problems emerge. And I use the word emerge as opposed to discover, because that perspective is we have to approach with humility, in that, as Pam has said, we don't have all the answers. No single party, agency, institution has all the answers. And that is the nature of the problem, as I've said, the nature of the problem of climate change. Let me at this point share a very practical kind of insight I've gotten from my work on tackling transboundary haze pollution, because I discovered that it has got parallels with climate change in terms of attributing liability. So in the work of transboundary haze, so we have got haze particles coming over in the air from across the border due to no fault of ours, with a big asterisk, due to no fault of ours, and it's a harm to us. Some suffer more than others, depending on their circumstances of their physical abilities, their physical situation, and their jobs, and how they arrange their lives. So different people are harmed differently, but there are no easy solution. And the linear approach to litigation makes it so difficult to actually build a case. And it's really important to hear from Dato' Lim that of the fact is that while the judiciary in Malaysia has consistently said, bring the pollution cases to court, come forth, right? And when cases do get in, like the recent Bukit Kiara case, judges have time and again risen to the occasion, and like in the last federal court panel in the Kiara case, delivered really, really good judgments and developed our jurisprudence around environmental disputes. But they are not getting through the doors of our courts. And that's a systemic challenge. It's systemic in the sense that it is, let's start with the body of law, are a bit clumsy in carrying these disputes because our laws need updating. Our laws have gaps. Our laws do not address climate change directly. They are fragmented across different fields, different sectors, different areas of expertise. The Environmental Quality Act 1974 regulates pollution. It doesn't protect the environment. So there are these gaps as a substantive right challenge. So it's hard to articulate when the environmental right that you're bringing, your cause of action, doesn't fit into established conventional pigeonholes, let's say. The other challenge is in the design of our rules of court, which are the rules of court are meant to facilitate disputes. And if we are talking about someone who suffered from haze pollution, it is really difficult to explain that I'm a right plaintiff to bring a complaint against parent company that has a subsidiary in Indonesia who was alleged to have had fires on their concession lands. And I'm sure your fires have emitted microscopic particulate matters of 2.5, which are capable of traveling 700 kilometers across my house in the last 3 weeks and causing me to have a bit more severe asthma. The lawyer would say, you don't have a good case, right? So, but increase the work in our work in researching transboundary haze pollution is not that all the people who suffer from haze pollution don't have a good case, is that the funnel in which we allow cases to come in isn't adapted, isn't well suited for these emergent cases of environmental justice, where some people are using the benefits of the environment and some others will have to bear the burden of their usage. So, and it's this unjust apportionment, this allocation of benefits and burdens among people, and the ability to resolve these disputes need to be expanded. Now, imagine if we've got no environmental pollution cases brought into court in recent years. What more a climate change dispute? And you know, we've got a crystal ball in the sense that we can look across to different jurisdictions, and we have seen arguments where judges, not arguments, where judges have had to decline cases because they say these are in the realm of policy. And these are for the policymakers, the folks in parliament, the folks in the executive, to argue around the politics that are involved. How do we balance between GDP and our international obligations to reduce our greenhouse gas emissions? How do we do that as a nation that is extremely poor because of mismanagement, and that is extremely reliant on oil and gas? And so how do we do that? What would be a just transition, for example? So that challenge for the judiciary, I think, and to judiciaries around the world is immense. And while that is important, I think the role of mediation as or thinking about alternative institutions to which disputes can be brought. And it's really important as well, I think Pam has talked about it, that the disputes are here, I think we're not just looking at disputes between parties, but also looking at how to resolve problems and how to resolve issues and challenges. So just like that example of someone experiencing sea level rise causing damage to his house, and we're seeing this right now in Klang. This is happening. Dry season, they are getting flooding. This has never happened before. Dry season, but they're having flooding every time the high tide comes in, and the tide comes higher. So this is the lived reality. I was just hearing it from YB Chao Santiago just 2 days ago as we were sitting down to think about some of these problems. And so paint is literally peeling off the walls because the walls and the foundations are too damp. So the house owner who cannot move because he can't buy another house, he may not want to say, I'm making a claim against my insurance if I have insurance, or I'm making a claim against my local authority, or I'm making a claim against the Ministry of Environment or someone that I can find blame, but instead I have this problem. And maybe all of you can sit down and we can have a discussion about what can we do about this. Because at my level as a homeowner, I don't know, but maybe the Ministry of Environment can then see this as a real visceral problem and sharpen how at a national federal level, we argue for better funding, better access to funds for adaptation, right? For example, against these impacts. So that is, there's so much potential in terms of these institutions. And it's not just potential, like from my perspective, I think it's not a matter of choice, because if we don't have it, we are asking people to constantly throw themselves against the doors of courts. And that is not an efficient way to go about it. The Kiara case that I talk about so glowingly, that was a difficult battle, right? 6 years, and among volunteers, that's just, it shouldn't be so difficult. So maybe I'll stop here, then we can have more discussions. Thank you.
Thank you so much, Mr. Q, for your stimulating presentation. You start off with conceptualizing the idea of what is climate change problem and climate change dispute, and you relate that to the United Nations initiatives. Actually, your remark trigger new perspective of what is actually climate change dispute in reality. You also talk about civilization heritage, and you mentioned just now about systemic challenges in environmental justice. And one of the example that you gave is, of course, on transboundary haze pollution. Just now, Yang Arif Dato also mentioned about the difficulty in providing evidence to prove exactly how do you prove that, you know, the health problem that you incur because of haze is actually coming from the smoke, which originally from a place. It can be a localized place, but how do we prove it? We require scientific evidence. How do you relate your health problem to that particular smoke that derived from the exact place at the same time? I mean, we require some forensic evidence on this, environmental forensic. Perhaps we have some medical doctors here from health sciences. Maybe we can discuss that later over lunch. But really, what you mentioned just now really triggered a lot of, you know, new ideas and concerns as well. Okay, thank you so much again, Mr. Q, for your presentation. So all the presenters have already presented. So we have completed our first session of our high-level dialogue. We are now starting our second session. The second session or second round is the question and answer session. Each speaker will be answering 3 questions which we have already prepared. So this is what I want to do. I will ask. I will shoot the question to each of you individually. Maybe I can start with asking all these questions to Yang Arif Datuk Lim. Datuk, do you want me to ask you all the 3 questions simultaneously, or do you want me like to ask you one question, you answer, and I will, you know, continue with the next question? Which one would you prefer, Datuk?
As you see fit, Prof. Or you
Okay.
may want to ask one and then move on to the next first and then come back in a rotation. It's also up to you. May not be so
Well,
mundane hearing from me.
no, it's okay. I look forward to hear more from you actually with your experience and whatnot, and then maybe you can pick up some of the points which has been presented by other presenters. So I will ask you. Okay, I will mention all the 3 questions. Maybe you can just answer them together or differently. Okay, the first question, Dato, is: are there sufficient environmental laws in Malaysia? Second question: what is the main challenge in pursuing public interest environmental litigation in Malaysia? And number 3, enforcement of environmental rights, national courts or international courts or arbitration? Can we hear your answer, Dato? Thank you.
Thank you, Prof. First question on the adequacy of laws. Generally, our laws are statutory laws as well as judge-made case laws. As far as environmental laws are concerned, I think at this juncture, they are mostly statutory laws and regulations. I did a quick research generally for West Malaysia for environmental laws. But before that, I think environment is also very widely defined. It can be problems of pollution, problems of biodiversity, problems of global warming, climate change, etc. So, but I think what we have, my quick research, we have for statutory laws, mainly is the Environmental Quality Act 1974, and there were 17 regulations made thereunder so far. We have the Waters Act 1920, National Forestry Act 84, Land Conservation Act 1960, and 17 others. So we have a lot of statutory laws. In addition, in Sabah itself, there is mainly the Environmental Protection Enactment 2002 and 7 other statutes. Sarawak, basically the Natural Resources and Environmental Ordinance and 8 other statutes. I think I agree with Jayal. I think he mentioned, I think perhaps some of these laws need amendment, updating. And one immediate problem I can think of as highlighted, difficulty of proof in environmental cases. One way perhaps I may suggest, it won't fully solve the problem, may partly help to solve the problem, is like in many statutes you can see in other areas, there is statutory reversal of burden. So to make it easier for the plaintiff, in a way, perhaps like introducing res ipsa loquitur principles statutorily into the laws. That's one way. But I think at the moment we have actually a lot of laws. Maybe the climate change, I understand an act is being proposed way back in 2009, and then 2018, I think it gained traction and then slowed down. I think it's coming up again. But y'all can confirm that. But I think beyond those, that is actually problems of enforcement, whether parties pursue their rights accordingly. That would be my first answer to the first question. Moving on, next one, right? It's the challenges in pursuing public interest litigation. Well, maybe I use that phrase public interest litigation very vaguely. There is, of course, enforcement of private rights as well as public law domain type of litigation. Private rights, of course, you start a court action on usually thought-based causes of action. Whereas the public interest will be normally against the statutory authorities for lack of enforcement of their duties or wrongful enforcement of powers which they have. There are not many cases going on the private basis. We see more so far, more judicial review cases against the authorities. I see the biggest problem lies in the standing, the locus standi problem. And I think the major one is our Bakun case in the 1990s. In the court appeal case of Ketua Pengarah Jabatan Alam Sekitar versus Kajing Tubing and others, where I think it failed on locus standi. But of course, the challenge was largely against the environmental department for the EIA, and they also wanted production of the EIA. So, of course, Justice Sriram, who led the Court of Appeal panel, then found lacking in locus standi of those people whose lands were taken away. Although I think locus standi, to me, I thought that it's quite clear they do have, but still, I think it failed in that case. Maybe now, perhaps with the RIMBA, the courts are now more open to giving locus standi and then go into the merits of the case. But somehow that seems, that is still good law at the moment. So, but of course, every law, every case is case sensitive, right? It may change. So that's one big problem, locus standi, which one has to clear, especially taking on authorities. And of course, even on the merits, is it a breach of a statutory duty or breach of statutory power? So it's very difficult to compel the authorities in exercise of power because it's discretion. That's another challenge you will get, and on the merits side of it. I think the other part is also, besides what I mentioned just now, reversal of burden. I'm not an expert lawyer in environmental law, but I am very fascinated with that movie. I don't know how many of you have watched that civil action movie acted by John Travolta. Perhaps, I just share some parts of it. You can see the complexity of it. It's a US water contamination case. And clearly, I think many villages were affected. And then, of course, things started going wrong. The lawyer, one by the name of Jen, that's where John Travolta acted as the lawyer. So, so the plaintiff approached him, but he's all the while a running down lawyer. Never did environmental law. Right? I've never done environmental law litigation. But somehow he decided to take the case. And in the US, it's on contingency basis. In other words, no fee. They will collect the fee from the winner, eventually, from the plaintiff, if the plaintiff wins. So, so he took on the case. But of course, in the US, somehow it's a jury trial. Unlike here, it's a judge trial all the way. So, but the plaintiff actually told Jen, the lawyer, that what I think we want is an apology from W.R. Grace in that case. But then the Jen, being a running down lawyer, said, no, they won't apologize. What you see, and an apology in them is they will pay you hundreds of thousands of ringgit in compensation. That is what will be the case. And then what eventually happened is in the US jurisdiction, because it's on contingency, the lawyer will have to underwrite the calling of experts to prove the case. And it turned out to be too scientific, and there's a need for many experts, and the law firm ran out of money. Cannot continue the case. And also what the lawyer wanted is to have a good time before the jury to show the problem, but it couldn't even reach the jury because to prove the technical point itself took ages. So at the end, what then happened is the lawyer ran out of money, forced to settle on a meager sum with W.R. Grace. In the end, the lawyer has to approach the plaintiff and then handed a check of a few $1,000 in settlement. And then I like this phrase in the movie at least. The plaintiff then asked Jen, you call that an apology with that sum of money? And the answer was, the only meaningful apology I can give you is my apologies. That was what happened. But of course, towards the end of the movie, Jen was able to retrieve some evidence in the course of it that W.R. Grace, I think, sent somebody to dump something into the river in disposal of the waste. And then he brought the evidence to the EPA in the US. And then W.R. Grace was then prosecuted. That was what the movie is about. But I think long and short of it is that it's not easy, I think, to pursue an environmental law case. That will be the other challenge, the proof. I think Jaya has mentioned that as well. I think the haze problem, we will have the same problem. We are trying to prove it. Third question, enforcement of environmental rights, national courts or international courts. I think if it is squarely problem involving domestic parties, both plaintiff, defendant, or prosecution and defense, all local parties, I think national courts is good. But once it's transnational, then I think the recourse has to be in the international court. I think the ICJ, I did some quick research on it. I'm still not sure, maybe you can confirm. Is there still an environmental court as a division of it? Because there were some cases brought up. And one of the recent ones I find is there was one between Costa Rica and Nicaragua over a matter that happened eventually in Nicaragua on polluting the environment. And the more recent one is a case by Greenpeace versus UK because of a granting of license of some drilling which affected the environment. Those were picked up by ICJ. But I suppose even the haze problem, if we want to take it up, maybe it should be between either a body equivalent to Greenpeace versus Indonesia in the ICJ perhaps. Or there's also the Permanent Court of Arbitration, I noticed, in The Hague that has heard arbitration cases on environment, although I think it's not so common. And there's also the proposal, actually, I noticed from the internet, to set up an international court of environment, somewhat outside the auspices of ICJ. I'm not sure whether you all will be one day advocating for that as well. No, that could be another possibility. Although I dare not imagine the cost of litigating there. That would be the other prohibition. If we are, an individual, for example, who we should take on, maybe even the Indonesian government, for example, in a haze case, may not be a good idea. So yes, these are the possibilities. So national courts good for domestic problems, some problems that has some international involvement. Then I think it is better to go to the international courts. Although we still have jurisdiction actually under Order 11 of our rules of court, but I think rarely done. And of course, even if you win, then you have to think of enforcement over the other side again. So yes, I'm happy to ask, or rather to answer any other questions that may
Thank you so
arise.
much, Arif Dato, for all your answers just now. Of course, I also have some question for you if I have time, but perhaps we can move to the next speaker. Okay, the next speaker will be Pam. Okay, we have 3 questions for you. First question is, when and how should mediation be used? Question 2, what role could a university play in mediation? And question 3, can you explain why taking action at the local level is important for the global problem of climate change? Please.
Yep, thank you. So the first question about when and how mediation should be used, and I'm going to speak specifically to the environmental type of mediation. Obviously, there's lots of ways and times mediation should be used. And there's kind of, I'm sure, more than these 3 examples, but I will give them as 3. If there is a concrete existing environmental regulatory issue that is happening, that would make sense to do mediation from some of the examples that we've talked, bringing people together. It could ideally be happening more when the policy is being planned, not afterwards. So that's one way, but having some particular issue that needs to be resolved. It would, again, in line with some of that preparatory preventative type, it would be really nice to see mediation used for interdisciplinary issues and bringing multi-party conflicts together. Again, we've spoken a lot about this today. So it's kind of, you could do it with existing problems. You can be looking at really prevention and infrastructure planning is one example of when things are being, a new road is being built, a new structure, the way we're using land use planning. It's a way that mediation could be brought forth. And then the final way is to be able to resolve post-disaster disputes. As we're seeing with climate change, there's going to be more impacts and how we're going to be resilient. Mediation could have a role there to bring people together to quickly be able to help resolve those post-disaster disputes. The second question is, what role can a university play with mediation? And I would say a lot. What I have found in working in this field in the last 4 or 5 years is that students are really interested in this topic of climate change and sustainability and trying to figure out some hope of how we can take action. So the university would be providing that leadership role, which it seems like IIUM has been doing a lot of that. And it also reflects on the community around you. So that is helpful. Obviously, building that institutional capacity by offering courses, talking about mediation and what roles it can play is very important. What we found is with the class structure, the students were able to really benefit from real life examples. We had a real interest in having their help work with stakeholders. I'm an office of one in our local government, but having the students be able to contact and reach multiple stakeholders was a real benefit to our community, because it would have taken me much longer without their help. And on the same side, the students get real life experience. It's also really helpful for the university to allow law students to see that there's other options besides just in the courts, and that maybe they're interested in mediation or facilitating these public forum discussions, because I feel, and it sounds like there's a need for this across all of our countries to have more of this discussion. And I would encourage that the university open the class not just to lawyers, but to those scientists or those interested in public policy, because it is important for the policymakers to understand this also. And then the third question was, action at the local level. Why is it important when this is really a global problem? What can we do locally? And we've talked about this being a really multifaceted, complicated issue, and it's really important for local government, where we are most connected to the community members, to be having these discussions and being able to provide solutions for the local person who's having the flooding issue, so that the local policy and community can work together to solve some actions, will give the community an understanding that will then allow them to understand why there's different regulatory policies that are happening at the state level and the federal level. So it can build that community will for larger things that are happening, and it will get them to see the benefits happening in their own community, which will expand to understanding why it's important to happen at the larger level, and ultimately help us realize that we're all in this together, because we're all going to be impacted, and we have neighbors that will be impacted, so we need to work together.
Thank you so much, Pam, for providing your answers to all the 3 questions. Maybe I can, move on to Mr. Q. I have also 3 questions for you, Mr. Q. Okay, are you ready? Number 1, I have not heard any climate change litigation in Malaysia yet. Why do you think we haven't seen more climate change cases in Malaysia? That is first question. Number 2, what could the first climate change litigation in Malaysia look like? And number 3, in the future, as we see more climate change disputes emerge, how should policymakers think about climate change disputes? Over to you.
Thank you, Dr. Maizatun. So for the first question, why haven't we seen more climate change cases in Malaysia yet? It is quite rich, the question being posed by you, because you're wearing the hat of the moderator, because as Dato' Lim has already quoted you as an authority on why climate change cases aren't making their coming through. So recalling what Dato' Lim has mentioned, I think we're not particularly litigious as a culture. There are difficulty in evidence, difficulty in framing these problems, difficulty in access to justice. From my perspective, I'll add a few more around, just framing it as a climate change problem, like I've mentioned earlier. So there could be disputes that are not brought in court. Maybe they were brought to the member of parliament. Maybe they were brought to a local council as a dispute between one party and another party. And then that defendant party probably feels this is extremely unfair to pin your misery, all of your misery on us. So much of what you're complaining about is in our jurisdiction, for example, is in our business, is in our problem. It is further upstream. Those are some systemic challenges. So I think why haven't we seen more? Yeah, we've talked about that there. The second question on what could the first climate change case in Malaysia look like? So maybe there have been climate change cases. It's just that we have not picked them up with our eyes. So like I say, in the example of sea level cases, maybe there have been cases that have been filed already between parties. That is a strand in the fabric of the climate change kind of continuum in terms of the problems and people who are potentially part of the solution. So with that said, maybe to directly answer the question, I think the typical place that looks like, from what's the lay of the land now, I think there are a lot of youth voices that are speaking up, that are asking very good questions, that are calling for a declaration of climate emergency in Malaysia, for much more serious and focused attention on climate change and all its related issues by people in the public sector. So I think youths, a textbook answer is, I think the youths would be a good, a very, very predictable place in which I think a case would be brought. But from a practical perspective, I think it can come from very unexpected places. So, you know, that people who are living in low-lying areas, as one example, who are, but by design, they are unlikely to bring cases because they're the only, you know, like the only asset that they have, which is their home, is already severely damaged, is already severely undervalued. They cannot sell it anymore because that whole area has got no real estate value. They cannot afford to move because that's the only piece of asset they have. And their lives, obviously, their livelihoods, their ability to hold the job are all devastated. They cannot take on mounting a climate change case. So will they be able to organize themselves? There's always the potential for that, but it will be close to a miracle, right? So but there's a need, right? So there are plaintiffs. There are people who wish to become plaintiffs and claimants. So it could also be from indigenous persons, groups suffering from that land grabbing, where, you know, forests, even secondary forest, parts of forest reserves, or state land where our indigenous peoples are currently maybe claiming native customary rights on, or they have been resettled there by a state government. So they're there, but they have problems with land tenure. They don't have a right to be there. And then tomorrow they are encountered with a developer who has turned up and said, now we are the owners of this land and we are turning this into a palm oil plantation. And those disputes are also a climate change dispute in the sense of the causes, deforestation that's happening. So the conversion of land use. So I think the youth groups would be where the word climate change would come, but the other disputes relate to climate change, but they would come under different banners, the banners of Orang Asli issues, land grabbing issues, peatland issues, for example. So that's my longer answer to your second question. So in the future, so your third question, in the future, as we see more climate change disputes emerge, how should policymakers think about climate change disputes? I think policymakers would benefit from this discussion. So it should be multifaceted. It should have, so policymakers, how should policymakers think about it? They need to be aware of their limited bandwidth. They need to be together with others to expand the collective bandwidth. So bandwidth means the ability to hold competing interests, facts, science, data, evidence, and their consequences. So that's really diffused. That takes a lot of bandwidth to handle, even when they're looking at a single issue in a single area. So they need to develop that self-awareness, that humility, that understanding, and then understanding that they need to be able to collaborate with others in order to expand the bandwidth in thinking about policy, in thinking about decision making. I think that would be the first step, and that towards, you know, more powerful kind of changes in the ways where policymakers would think about climate change disputes. I think by design characteristics, civil society participation must be included, must be designed in, not as an afterthought, not as window dressing, not as tick boxing, but meaningful, where ideas are actively sought, where participation are actively sought, and actively sought includes understanding that the people that you're trying to engage, the stakeholders, are busy, they have their own lives, they have their own commitments, and so consultation should be meaningful and intentional. And also the importance of representation and diversity. So women should be actively encouraged. So I think a gender lens must be there. An inclusiveness for youths as well is very important, because climate change, when youths are in the room, the perspective immediately changes. So that really helps expand the bandwidth, helps expand the horizon, and keeps all the issues in focus. Yeah, thank you.
Thank you so much for your answer, Mr. Q. So we have one youth here, Ms. Chu E, to answer 3 questions. Okay, here are the questions, Chu. How can investors and shareholders influence companies to take stronger ESG measures for climate change mitigation? That is number 1. Number 2, what role can government regulation play in enforcing ESG standards, and how can this lead to positive impacts on climate change? And last question, what is the impact of ESG-focused investing on climate change? Has there been evidence of tangible environmental benefits from this practice? Over to you.
Thank you, Dr. Maizatun. So on to your first question, how can investors and shareholders influence companies? Well, there are 2 ways. First is through shareholders' resolutions and voting. So shareholders can use their voting rights to influence company policies and push for more climate-friendly practices. So like in the UK, for example, they have this initiative called Say on Climate Resolution. So it's an initiative to encourage shareholders to move resolutions for companies to set out specific targets for greenhouse gas emission reduction over time, to improve their reporting on the impact of climate change on their businesses, and also to align their corporate behavior with Paris Agreement. Now, so I did a bit of research as well. The Say on Climate resolutions requisitioned by shareholders of UK listed companies had in fact increased from 30 in 2020 to 58 in 2021. And to 74 in 2022. So we are looking at shareholders taking more active role in moving resolutions to let the directors know what their views are on the sustainability issues, right? Now, although legally speaking, I would say that these type of resolutions may be construed as non-binding because they pertain to the day-to-day running of the companies, which are within the purview of the directors, as opposed to the shareholders, right? But they are very powerful tools to influence the decision-making process of the directors, because the directors know that, okay, these are the views of the shareholders, so they cannot just totally disregard the views of the shareholders. So that's the first way. Second way is what I would call investment and divestment. So investors can choose to divest from companies that do not meet ESG standards. It sends a very powerful message when you withdraw your investments. And then you can choose to invest in more sustainable, friendly companies. So on to your second question, which is quite apt because we have a representative from the ministry as well. How government, what role can government regulation play, right, in enforcing ESG standards, and how can this lead to positive impact on climate change? So we're looking in other jurisdictions a move towards mandatory disclosures of greenhouse gas emission, particularly for large companies. So for Europe, for example, right, I think they're moving towards requiring disclosures on companies' use of carbon credits as well. So that's one. Number 2, regulatory standards. So the government can set standards for ESG performance, such as limiting emission or requiring energy efficiency in their building. Number 3, incentive. So you can offer incentives such as tax breaks or subsidies for companies that meet certain ESG standards. I think the US not very long ago, they just passed their law on carbon tax credits. So giving incentives to companies to reduce their carbon emission. Number 4, imposing penalties on companies to meet certain ESG that fail to meet certain ESG standards. So this will serve as a deterrent and also to encourage companies to improve their practices. But of course, all of this cannot be immediately implemented. it has to be implemented over a course of time. And what is also important is the fifth step to be taken, that is to provide infrastructure and structural support, especially on small and medium enterprise, for them to meet their ESG targets. So for example, encouraging renewable energy. Like, I think it's very difficult for SMEs to transition to solar power, for example, in Malaysia, right? Because there's just a limited number that's available annually. So we should look into this infrastructure and structural support. You know, SMEs particularly, they don't know how to go about with tracking their carbon emission. So if you don't provide them with that kind of infrastructure, it's very difficult for them to transition towards more sustainable practices. So yeah. Now the third question, the impact of ESG focused investing on climate change and whether there's any evidence on tangible environmental benefits, right? I did a little bit of research. So apparently there was a study done in 2020 that explores the relationship between ESG and investments and carbon emission in China. So the result of the study was that there's a 1% increase in environmental investment, so ESG focused investment, would actually cause 0.246% decrease in carbon emission and 0.558% decrease in carbon emission intensity. So study has been done in China. There was also a study done by a university in Italy that ESG based investments have there's a correlation between correlation and causation between ESG based investments and reduction in carbon emission. Now, there is no study done in Malaysia yet, so maybe this is an area that CCPR can look at, whether you know, ESG investment will lead to reduction in carbon emission in China, in Malaysia. But what I also know is that there have been a number of studies done showing that companies adopting sustainable practices in their business operations have actually record better profitability. Not sure whether it has been done in Malaysia, but I know that in other jurisdictions, studies have been done. So the tangible evidence of benefits arising from ESG focused investment and ESG focused business practices for companies.
Thank you so much, Chu Yi, for your answer. I have to study from you on ESG. Actually, you have so many points that I have to take. Thank you actually for the input just now with regard to ESG investment. Whether, you know, I'm sure, of course, there need to be a study. You need to prove at least the theory, or perhaps to confirm that, you know, the practice of ESG investment in ESG can actually reduce carbon emission in relation to climate change, or otherwise not only in relation to profit. Okay. Actually, it's about time for lunch, but perhaps if anyone here who really have a question that you really need to ask the speaker, is there? Would you like to ask a question? Yeah.
Yes. Okay. Thank you very much, Dr. Maizatun. Okay. First and foremost, thanks to the presenters, thanks to the speakers for the very fantastic and also very awesome presentation. I'm attracted to respond just a little bit on the ESG because you know, we are the same generation probably. Okay, Chu Yi. Okay, with regard to the ESG, some of the points you made that I agree with, and some of the points I agree to disagree. Okay, let's go to the point that I agree. On the ESG, right? Environment, you mentioned about the physical risk, and then you move on the transitional risk and also reputational risk and whatnot, right? And this is because of the carbon emission released by the company, for example, and then it moved to the second component of S, social, basically. So it affects the rights of livelihood, as mentioned by Mr. Gioyo in his presentation, and also right to have a good quality of life, right to access, enjoy a good quality of water and also air. And then, and because of that, there's a G aspects on governance, right? And then the G aspects of governance, it relates to the director's duties as well under Section 213 of the Companies Act, right? The directors have a certain responsibility. One of the responsibility is to mitigate risk. And then because of this, it can cause a reputational risk to the company and whatnot. And then the point that I think there's I would say the law is there to force the company to basically to follow. There's a corporate director's liability with regard to the environmental issues on the climate change. But what I can see, there's a loophole with regard to the law with regard to the climate change, as we have the section 78 of the MSCC where the company can be made liable under corporate liability, right? But there is none. Basically how to make sure that the company comply with the on the issue of climate change. And then the point that I disagree because of that, right? Because of these points, the point that I quite have my own opinion on this on the CSR. Because of directors, they have the duty to mitigate risk. One of them is on the reputational risk. And then it goes back on the issue of CSR, how to mitigate and also remedial action. Probably they can go by way of CSR, right? So that is basically for me, ESG and also CSR is interrelated somehow, as opposed to a role in silo. That is just basically my comments on the ESG.
So the first point is quite interesting, right? No liability on companies if they don't take steps to mitigate the impact of what they do to the climate. Yeah, so I think that's the loophole in the law. Hopefully it will be addressed in the Climate Change Act to some extent, impose certain obligations on businesses. You raise an interesting issue on directors' duties as well. And in fact, this is really an emerging area, yeah. Because the duty of the director is really to act in the best interest of the shareholders, right? And sorry, the best interest of the company. So what do you mean by best interest of the company? So the emerging opinion is that best interest of the company includes addressing transition risks as well as physical risks of climate change to the company. So if you don't do that and the company's bottom line suffer as a result of the negative impact of climate change, then you are liable as a director. Yeah, so that's on the director's duty portion. And as to CSR and ESG, yeah, I mean, yeah, to some extent it's right. They're not like completely independent. So ESG, but at the same time, ESG is not just a repackaging of CSR. CSR, when companies do not do any CSR activity, there's no negative implications. That's the status quo. CSR is just something extra. But we have moved on to the age where ESG is the status quo. And if you don't do it, then you are actually going against the status quo. That's how I look at it.
Thank you very much for the question and for the answer. Unfortunately, we don't have enough time for more questions. Perhaps if others you have questions to ask the speaker, we can do it over lunch. Well, I would like to round up our discussion and presentation for today. Just a short summary. Started off with presentation by Young Arif on climate change litigation, and then Pam with climate change mediation, QE with ESG in climate change mitigation, and last but not least, Mr. Q with climate change disputes. We have indeed learned a lot from inputs that you have provided in your presentation. Thank you very much. Now I will end our high-level dialogue, and I will hand over to the MC. Thank you very much.
Thank you, Dr. Mazatun. Before we end our climate change dialogue, I would like to invite Dr. Wan Muhammad Zul Hafiz, accompanied by Dr. Mazatun, to give a token of appreciation. I think it should be there. Right, the first token of appreciation is to be given to the Young Arif Datuk Lim Chong Fong. Secondly, to Ms. Pam Adams. Thirdly, to Ms. Kwong Chiu Yi. Fourthly, to Mr. Q Jia Yao. And lastly, to Mr. Ahmad Farid Muhammad. Thank you, Dr. Zulhafiz and Dr. Mazatun. Members of the floor, we shall now have a lunch break and we'll continue with our training of trainers for environment and climate change mediation at 2 p.m. Please enjoy your luncheon. Thank you, everyone.